Okay, last one. Mistake. What is mistake? Now here we're not talking about someone, oops, making a mistake. Oh, tersilap. Oh, no. Bukan tersilap biasa. Mistake in contract basically affects the validity of the contract. Now, how does it affect the validity of contract? Basically, it can occur, under Section 21, This is where both parties are making a mistake. We're not talking about someone, just one person making a small mistake in the contract. Here we're talking about common or mutual mistake. Both of the contracting parties are under a mistaken belief regarding the contract. Dia memang kedua-duanya buat kesilapan, common mistake yang kedua-duanya silap tentang fakta yang penting dalam kontrak tu. Okay, fact which is essential to the agreement. So the mistake is not just about a mistake in typing ke, bukan. We are talking about mistake regarding a fact which is essential to the agreement. Fakta yang penting dalam kontrak tu. Okay, so what are those fact which cause them? Before that, the effect of mistake is that the contract is void. Ni satu-satunya yang menyebabkan contract is void. Tak ada free consent because of mistake, contract is void. Bukan voidable. Kalau tadi we have seen coercion, undue influence, fraud, misrep, semua ni menyebabkan the contract to be voidable. You have a choice, but here mistake, the contract is void. You don't have a choice. You cannot proceed with the contract. It has to end there. Okay. Alright, what are those situations that falls under mistake of fact essential to the agreement? Apa yang essential to the agreement? Apa yang penting? Fakta tentang apa yang dia tersilap yang penting kepada agreement? Firstly, mistake as to the existence of subject matter of the contract. Subject matter of the contract. Let's say the subject matter of the contract is a house. Ali wants to sell his house to Abu. Alright, and unknown to both of them, the house is no longer there. Maybe the house has been damaged. Maybe, for whatever reason, the house is no longer there. Okay, so you cannot proceed with something that is no longer there. All right, so both of them were not aware. All right, so this is a mistake as to the existence of the subject matter of the contract. Okay, so the contract is void. Secondly, mistake as to the identity of the subject matter of the contract. As someone wants to buy something and the seller wants to sell it, all right, but the seller is thinking of something else, the buyer is also thinking of something else. So the identity is not the same as what both of them are thinking. So there's no meeting of the minds here. And so there are mistaken belief as to the subject matter of the contract. For example, in the case of Raffles against Visual House. Now, what happened in this case is that the seller wanted to sell goods which are on board a ship, that was supposed to depart from a particular port. The buyer also wanted to buy, goods which are on board the ship, but it's of a different shape. You see, both of them are thinking of different shapes. There were two different shapes of the same name coming from the same port. All right, so in this situation there is no meeting of the minds, because one person is thinking of one thing, the other person is thinking of the goods on board another ship. All right, so there was mistake as to the identity of the subject matter of the contract. And lastly, mistake as to the possibility of performing the contract. Both of them thought that that thing can be done, but in actual fact, that cannot be done. And they think that it can be performed. The contract can be performed. Let's say, for example, they enter into a contract to plant certain plants on a particular land. They thought that it can be done, but actually it's not. Tak boleh. Benda tu memang kedua-dua mungkin tak ada kepakaran. They thought benda tu boleh dibuat, sebenarnya tak boleh. Okay, so you cannot enter into such contract where it cannot be performed. There's no possibility as to performing the contract. So both are under a mistaken belief. Sheikh Brothers Limited against Oshner. This is a case whereby the the parties to the contract enter into a contract for the purposes of manufacturing, manufacturing from a plant which is called the sisal. So they thought that it can be produced. They have already agreed on X number of the product, the sisal, but it turns out to be that it cannot be done. Okay, so when they enter into a contract, they thought that it can be done. They are under a mistaken belief as to the possibility of performing the contract. Now, what happens if it is just one person who makes the mistake? Now, this is what we call as unilateral mistake. Unilateral mistake is when one person only is making a mistake. Now, in that situation, the contract is still valid. Kalau seorang je yang tersilap, sebenarnya their contract is actually can be performed. It can be performed. There's no mistaken belief as to the any of the essential facts, and the contract is still valid. So remember, mistake that would affect free consent is the mistake that is made by both of the contracting parties. It has to be a common mistake. Okay. Now, what happens if someone thinks that he is signing something, and can he say that, oh, I don't know what I signed? Alright, oh, I just sign saja. Oh, PTPTN tu kena bayar balik. Oh, saya tak tahu pun, saya sign aja. Tak boleh. Alright, because basically the general rule is that a person is bound by the terms of the contract that he signs. He cannot say that, oh, I didn't read the contract before I signed. Tak boleh. You are supposed to have read the contract before you signed it. So you cannot say that, oh, saya tak tahu. Oh, ya ke, kena bayar balik benda ni. Kan bagi free je. Tak boleh. Alright, you've got to understand what you sign. You've got to read before you sign it. So the moment you sign it, whether or not you read it, kalau you dah sign, you baca ke, you tak baca ke, you faham ke, tak faham ke, the contract is still binding on you. This case that laid down this rule, this general rule, is the case of Nasreen against Grokop. Now, this was a British case. Now, what happened was that this lady, Nasreen ni, dia beli satu what do you call it, this dispenser, cigarette machine ni. This is actually this picture ni is actually the machine produced by this company, Grokop ni. So what happened was that she bought this machine, and she signed the contract, which basically says that you cannot claim kalau misalnya ada apa-apa rosak ke apa ke, you cannot claim against whatever that is stated in the contract. You cannot add on lah. Alright, whatever you cannot claim for whatever rights and all that. But later on, she discovered that this machine is actually a machine to dispense cigarette zaman dulu. Machine untuk beli cigarette lah, daripada machine macam vending machine kita beli air, dia beli rokok. So what happened was that dia letak dekat kedai dia, and tengok machine tu rosak. Okay, and she wanted to claim from the company. But there was a clause that she has already signed. Alright, so she said that she didn't realize that was in there. But the court decided no. You've got to be bound by whatever terms in the contract that you sign. Similarly, this rule was also followed in the case of Subramaniam against Ratnam. Basically, once you sign the contract, you are bound by the contract. You cannot say that you have not read it. You cannot say that you don't understand what it says. But ni general rule. Dalam kontrak dia kadang-kadang ada general rule, dia ada exceptions. You have seen kalau capacity, general rule, minor cannot enter contract, tapi ada exceptions. Ada banyak situation, contract mesti ada consideration. Kalau tak ada consideration, contract is void, tapi ada exceptions dia. Sama juga di sini, ada exceptions juga. Now, what is the exception to mistake as to documents? This is called the plea of non-as factum. Plea of non-as factum basically means that when you are under a mistaken belief as to the character and class of the document. And you tak boleh kata, oh saya tak tahu apa saya sign, saya tak faham. You cannot just say that. You are signing something, you must be able to understand what it says. But if you do not understand, your mistake is because of illiteracy. You memang buta huruf, tak boleh baca. blindness. Kalau dia buta, memang dia tak boleh baca dan kontrak tu tak ada dalam braille. Sensibility of the signer. Bila you sign the contract tu, mungkin that person when he sign the contract, dia tak tahu what he is signing. In the sense that mungkin he is affected, his sensibility is affected because mungkin dia sakit. Fraudulent conduct by the other person. Ni ada kait dengan fraud. Dia suruh orang tu sign, orang tu dah lah illiterate, tak boleh baca. Tapi dia tipu pula, bagi tahu apa benda yang tak betul tentang kontrak yang dia sign tu. So in that situation, what you are signing, you are under mistaken belief as to the character and class of the document. You think that you're signing for something else, but it's actually not what it is. For example, in the case of Foster against McKinnon and Awang bin Omar against Haji Omar. Now you've got to, in Foster against McKinnon, basically it lays down that mistaken belief, if you can read, then if it's in a different language altogether and you have no ability to verify on what was stated in the contract, then yes, that is you can use a plea of non-aspectum. In the case of Awang bin Haji Omar, he was asked to sign a document. He thought that he is signing as just a witness, sebagai saksi saja. Dia tak boleh baca. Okay, it was in a different language and dia tak faham. Alright, so dia ingat dia sign sebagai saksi. Rupa-rupanya dia sign sebagai guarantor. Those are two different capacities. When you sign as saksi, you're just basically saying, oh yeah, betul, saya menyaksikan orang ini telah tanda tangan. Tapi when you sign as a guarantor, you are saying that kalau orang tu tak bayar, kalau orang tu tak mampu nak bayar, saya akan bayar. Those are two different class of documents, two different characters of documents. So he is under mistaken belief as to what he is signing, and because he did not understand what the document was about, and the document is in fact of a different purpose altogether, different class altogether. All right, okay. So basically, to sum up, is that what you have learned is, well, you have learned free consent as an element of contract. How it affects a contract, what causes contract not to be freely given, and the validity of the contract if there is things like coercion, fraud, undue influence, misrepresentation, and mistake.